Kia ora koutou. Good afternoon, everyone, and thank you for joining me here today. I'm really delighted to be here, and thank you to Ray and the rest of the staff at the Office of the Privacy Commissioner in New Zealand for organising this. It's always great to be part of Privacy Week. It's something I'm really passionate about. And today, I hope you find this an interesting overview of 3 different industries. I should just say I'm very happy to take questions at the end. My plan is to speak for 30 to 40 minutes, and I'm going to introduce myself properly now, and then I'll come back to my recap. So I'm Dr. Andelka Phillips. The D is pronounced like a J, so Andelka. I am an academic affiliate currently at the Helix Centre at the University of Oxford and also affiliated to the Bioethics Institute in Ghent. But I'm a legal researcher and writer, and I've taught law in 4 countries now, including Aotearoa, New Zealand. And I'm a New Zealander, and I'm currently here at the moment, but I'm joining you remotely. And today I'm going to talk about work that will really give you an overview based on a chapter that's forthcoming in an intellectual property collection. But I'm also going to talk a little bit more about direct-to-consumer genetic testing, which I've written quite widely about because I know it's still quite topical for a lot of you, and there's been a bit more news about 23andMe and its data breach in the last few weeks and months. So I will talk a bit about that quite early on, and I'll talk about these 3 industries today as well. And then I'm happy to take questions at the end, but I am also very happy to be contacted with questions or to talk about collaboration possibilities. So thank you again. So my talk today does draw upon this forthcoming chapter called Owning Me, Owning You. That's where the title of the talk comes from. But I've also put some links to my related work, both my independent work and my work with Dr. Jan Charbonneau in the slide. I have a more comprehensive list of publications towards the end of these slides, and also a video from a project that I did that was funded by the Boren Foundation, which I jointly ran with Professor Samuel Betcher. So if you're interested in any of those things, you'll be able to access these slides after the event and read a bit more about my work. But to begin with today, I'm going to be talking about 3 industries. So the first is direct-to-consumer genetic testing, which is sometimes termed personal genomics or consumer genomics or even commercial genomics. But that is the industry that has allowed people to order genetic tests as consumer services. This is typically sold online, where a person orders a test through a website and the company then sends them a test kit to take a DNA sample, normally in the form of a saliva sample or a cheek swab. And then the person sends that kit back to the company for processing, and the company performs genetic sequencing and analysis services. Now, I'm not just talking about that industry. That industry is something I've been writing about for the last, well, more than a decade. But I'm also going to be talking today about 2 other related industries. The thing that really unites all 3 industries is their reliance on personal data, but also sensitive data. So I'm going to talk about wearable technology as one example of Internet of Things, and although wearable technology encompasses quite a wide range of products now, in the context of this talk and the chapter I wrote, I'm thinking about wearable fitness monitors that take the form of wristbands or watches or worn on the finger as rings. So Fitbit, Garmin, and Aura are good examples of that. But then I'm also going to talk about the online dating industry. And because I've done so much work around direct-to-consumer testing, and that's been very topical in the last few years, but I've also had an interest through my teaching work too in the Internet of Things, and I'm also more broadly interested in privacy online. I just wondered about the similarities that we might find across these industries if we looked at them. So the idea for this really came about through thinking about what types of rights might a company be wanting to acquire in consumers' data and content. And all of these rights are acquired through privacy policies and online contracts. And one thing I would like to skip ahead to, just to get you to keep thinking about as we go along, is how many contracts and privacy policies have you encountered online in your lifetime? How many of them do you think you've actually read? And those questions are just things I'd like you to keep in mind as we proceed, because they really are problematic in terms of the types of rights that a company might acquire that are buried in very lengthy contracts. So I did mention this in my webinar last year, but just to refresh your memory and to also give other people who weren't there some insight into this, this was a study that the Norwegian Consumer Council did in 2016, where they actually did a live app terms and conditions readathon, but they estimated that the average smartphone at that time contained 250,000 words of app terms and conditions. These are basically 250,000 words of terms and conditions that people aren't reading. And a more recent study, which this is a shortened version from Samuel Betcher and another colleague of his, where they looked at the readability of the terms and conditions of the 500 most popular US websites, and they found that more than 90% of those were written at the level of an academic journal article. Now, I've worked in universities, I enjoy it, and I enjoy teaching, but I'm sure even those of you who are lawyers or have studied law, have an interest in law, will know that there are many academic articles that, even when we have the training, we may struggle to understand at times. So expecting everyone to be able to get to grips with these really lengthy contracts full of legalese is a really problematic thing, and we really do need reform to allow people to be able to make more informed choices and actually exercise their autonomy online. So in looking at these three industries, what I set out to do is I used them as 3 case studies. I took several examples from each industry, and I was looking at the intellectual property license clauses, which companies typically include in their terms and conditions or terms of service document. Now, these intellectual property licenses are straightforward in some ways. It's normal for a company to want to protect its intellectual property, and it's normal for them to want to be able to acquire rights through their products and services that they can utilize at a future date in future products and services. Now, I do note that there is a question so far, but I will take questions at the end. But please feel free to post them, and I will try to address as many as possible at the end of this talk. And the point I'd like people to take away from this in thinking about intellectual property rights of businesses that rely on services and products that handle sensitive data is that intellectual property licenses are really where privacy rights and intellectual property rights collide to some extent. And an entity might actually be acquiring a license to use a consumer's content that might include information that they might really not anticipate being reused in that way. It's very normal for businesses, especially in the health tech space, to want to do secondary research. And I would just like to note that the 23andMe example is a really good one just to highlight the problems that can occur. Now, 23andMe, some of you will have done a test with them, or you may have done a test with Ancestry, but 23andMe suffered a major data breach in 2023. In the aftermath of that, there's been some 40 class actions filed in the US, and at least one in Canada that's still pending in the province of British Columbia. But there was actually a settlement that was meant to be provisionally approved at the end of last year. That's a $30 million settlement for the 40-some class actions in the US. But unfortunately, since then, 23andMe has really suffered, it's gone from bad to worse in terms of its financial situation and is going through the process of Chapter 11 bankruptcy. And that has meant that this settlement, although I have concerns about the actual amounts that an individual consumer would be able to claim, that settlement of $30 million may not end up being that amount. It may be a lot less. It may mean that most consumers who suffered identity theft or had other financial loss may actually have very little redress in the end, because at the moment the settlement is on hold, and 23andMe's lawyers are also challenging this. So if you're interested in learning a bit more about this is a short article from TechCrunch, which will also link out to a few other useful resources, including a source talking about concerns that have been raised in the US Congress about what will happen to consumers' data in this space. And just to give you some context here, so 23andMe at the time of the breach had around 14 million consumers in their database. Some 6.9 million people's data was compromised. There were examples of some of the data being offered for sale on the dark web to the Chinese government, and specific targeting of people of Chinese and Ashkenazi Jewish heritage. But overall, this is a massive amount of people, and as we share a lot of our DNA with our families, it's not just those 6.9 million people who may have problems, it's all of their wider family groups that could potentially have a problem. And in the US, it's much more of a problem in terms of how genetic testing could impact your health insurance. But there's a lot of other things that could be used against an individual or their family's interests, because the data that was released actually did also include home addresses and dates of birth, and as well as some health data potentially, and some actual genetic data. So a lot, and different photos were also released as well. There were lots of different forms of data that were actually available. And one of the really problematic things about this breach was that it was facilitated by credential stuffing. Now, credential stuffing occurs where an attacker is able to access the login details of people that are used on multiple sites to essentially log in as that user. So for instance, if you are creating an account on a website by linking it to your Facebook or Google or Apple account, that usually means you're going to be using the same password and same username on all of those sites, because you're just linking it to the other platform. So if someone then gains your credentials from that platform, it means they can log in as you on other sites. And that meant that they were able to access quite a large number of accounts through that method, which meant they weren't even trying to guess passwords. They could just use the passwords and usernames as though they were the actual user. Now, one thing I would like you to take away from my talk today is that is really problematic. If we have services that rely on sensitive data, then we should really be getting businesses to engage in better practices. There's been a lot of talk and also a lot of actually requirements in data protection and privacy law internationally that encourage or require a data protection by design approach or security by design approach. But these are things that businesses really need to take to heart, and we do need a lot more work to be done in this space to protect people, because even if a business is doing their best, it's true that no business will be completely secure from a cyber attack. So it's something that we all need to think about, but in the context of sensitive services, I do think that we shouldn't be linking accounts in this way. It's something that we really need reform on. And the other point just to take away here is that although $30 million US seems like a big settlement, the fact that this is on hold, and even if it goes ahead as it was originally approved, the largest amount a person could claim individually was $10,000 US, even if they had been the victim of identity theft. It just shows that even if there is a big settlement, the actual redress for an individual person might be very low or very limited. So the other thing I just wanted to mention too is that in its handling of the breach, 23andMe has not behaved in the best way. It blamed its customers in large part for the breach at times, and that is really not good practice or good PR. So it's just something to be conscious of. This is not something that you want to follow. And coming back to the three industries that I'm talking about today, I just wanted to give that little mention of 23andMe and what's going on and the problems of compensation and large scale data breaches. Uh, the thing just to note too is one of the other reasons I thought of looking at these industries together is that all of them have had security problems. There's been large scale data breaches, and it's just something to be aware of. It's also just important to understand that many people are meeting their partners online today. I was very lucky that I've never had to do online dating because I've been married for a very long time, actually. Uh, but when you are using any of these services, they are collecting a lot of data. And this isn't unique to online dating. Wearable tech providers collect a lot of different forms of data. Uh, a lot of that data may actually reveal your location at particular times. This is true too of dating services because one of the security problems that Tinder has experienced involved the location of all its users being visible to all its other users for a period of time. And that location was accurate really within about 100 feet, which is fairly accurate if you want to know where someone is and you knew what they looked like. Uh, and the other thing just to be aware of is that all of these spaces are really up for grabs. Health data matters, it is valuable. And although you might think that uh, online dating doesn't really have a lot of data that relates to health, that actually is changing, particularly with the advent of COVID-19, as well as increasing the number of people who went online to find love. It has actually increased the range of health information that online dating platforms have. So, for instance, Tinder actually introduced a vaccination status badge, which was allowing people who were trying to find a match on it to see whether the person had been vaccinated. This is health information. There's also been information about HIV status. Uh, and there's been other problems too in relation to femtech platforms as well. But today I just wanted to highlight these three industries and just get you to reflect on some of this. So, coming back to the problems of contracting in this space and the problems of what you're actually agreeing to. So, there's been a few sort of fun examples of things that are unenforceable being inserted into contracts just to highlight the fact that people don't read contracts. So remember I said 250,000 words of contractual terms on the average smartphone in Norway in 2016. That was before COVID-19. So just thinking about the amount of services that have shifted online and the likelihood of the volume increasing quite dramatically. So there'll be a lot more terms on your phones now. But there's been several free Wi-Fi experiments, and this is quite a fun one where Purple Wi-Fi in Australia got 22,000 people to agree to 1,000 hours of community service, which included really weird things like hugging stray cats and dogs, but also cleaning public toilets and doing a range of other things. Now, this is not enforceable, but it highlights the types of salient, important things that are often buried in these long contracts. And when I've looked at the consumer genomics industry, I would say that I actually conducted a review. This is drawn upon in my book on the industry called Buying Yourself on the Internet. And I actually looked at 71 contracts from companies that marketed tests for health purposes at that time. Now, although we're talking about privacy today and we're talking about intellectual property, we need to also think about consumer protection and contract law in this space. So New Zealand has very similar legislative control, which is basically legislation that protects us from bad terms in contracts. We have very similar legislation to the legislation in Australia and also throughout the EU, which really seeks to protect people from unfair terms overall. Now, an example of an unfair term, which could also challenge the validity of an entire contract, is a clause that allows terms to change at any time. This is very common in the context of personal genomics, but it's also quite common more broadly throughout the internet on many different platforms. There's also often been clauses that will try to limit a person's ability to sue, and also things like indemnity clauses, which purport to make you as a consumer support the company if it gets sued, basically, even if they've done something wrong. So I found a lot of problematic clauses across the personal genomics direct consumer genetic testing industry, but these clauses are also likely to be found in the context of wearable tech and online dating. And I'm not going to use all the examples I use in the chapter. I'm just going to use a few examples today just to highlight some of the problems here in terms of the scope of these clauses, what they might mean for your rights, and just hopefully to get you as consumers and as businesses to think of how we might do things a bit better. So to start with, this is an extract from the license clause from 23andMe. My mouse is doing something weird. I'll just move. Okay, so this is the clause from 23andMe. This is from the US version, and the international version, which applies to New Zealand, contains the same clause. You'll see that it is a clause that actually provides very broadly for the company. Whoops, I'll just go back. Something weird happened there. Sorry. You'll see that it applies to its successors and sub-licensors. But what I'm going to do is I have a better slide that breaks this down a bit more. So I just want to highlight, it's a very long term. Those of you who are really interested in this can have a look at the slides after this talk. And you can also download the contract if you want to read it yourself and have a think about it. But when it talks about user content, it does specifically exclude genetic or health information, which is a good thing. However, in terms of what is covered by user content and its definition of that, it covers most other things that a user might share. And just to think about the similarities between these three industries that I'm talking about, all of these do tend to encourage social networking. The genetic testing industry is very clear on that because they try to connect people with unknown relatives, and they do encourage sharing information. So this user content that the company is acquiring a license to does cover most things that a user might post apart from their genetic information. But it also applies to things that are shared both privately and publicly, and it's framed on an irrevocable basis. The other thing just to note about this, which is quite important, is that the license is not only for 23andMe, but it applies to 23andMe's successors and affiliates. So that means if 23andMe is sold on, its assets are sold on to different entities, that license could carry over. It could also already carry over to its affiliates currently. And just to note that this industry is one that has never really made a profit. It's never really made a profit from the sale of the genetic tests it sells. It's made a profit from the partnerships and mergers it can enter into and the reuse of consumer data. So it's always been valuable to the industry for the companies to have a much larger number of consumers' data rather than to really focus on the quality of the services for an individual consumer. And that means that several of them have had partnerships with other industries, And 23andMe has at least had 14 partnerships with pharmaceutical companies, and those would qualify as affiliates. So this license can carry over to that. So that's a starting point. It's irrevocable, covers all sorts of things. And even though it doesn't apply to genetic or health information, there are loopholes in the contract and privacy policy overall. And you'll see that the concerns have been raised in the last couple of months in the US Congress, mentioned that people have had difficulties deleting their data from 23andMe's database. And that's something I would just say too, that I'm not surprised by that. Even though the company has allowed for people to withdraw their consent from participating in research, if someone had consented to participate in medical research projects and then later withdrew that consent, that data would still be used in projects that had started before they withdrew the consent. And there's always been other things that they could do on the basis of quality checking, which has made it seem to me that it would be difficult to ensure that all this data was deleted. So moving on to an example of wearable tech. This is from Garmin. You'll see that by submitting user submissions to the site, you grant or warrant that you're the owner of such material, and it's been expressly granted, and you give a perpetual irrevocable license as well. So overall, because it's a long clause, I'll let you have a look at it after this talk if you're still interested. It's very similar to the 23andMe clause, and 23andMe's clause is very similar to the Ancestry DNA clause and several other prominent companies in this space. And the irrevocable thing is interesting because it means you can't withdraw this license, at least not on the basis in the way it's framed. My concern, though, is that to a large extent, a lot of these clauses may not be enforceable because they do breach applicable privacy and consumer protection law. But the problem with that is it's still very difficult for an individual person to challenge a large multinational company. And particularly when things go wrong, like they have with 23andMe, what happens to all those consumers' data is much harder for them to really police that when companies' assets are being sold on. The other thing is just to recognize that this clause covers a very broad range of potential formats for use of content, and including both known and future technologies. And it's quite common for businesses to want to do this. I also wanted to highlight the Fitbit clause. Now, this is a version from their terms of service in New Zealand. You'll see they also have a worldwide royalty-free license to distribute your content in whole or in part. But the really kind of scary thing here is that they do this, including the use of your name and likeness in any media. So it's very similar to the Garmin clause in 23andMe, but it mentions specifically your name and license. This was present even in the EU terms of service on the Irish website that I've accessed. This, I think, is really, I would say, difficult to enforce in the EU context, but the problem is really that it's there, and businesses need to think more about what they really want to put in these contracts. And if they want to make privacy-friendly services, they need to really change some of the practices here. Now, another example is from online dating industry and Match.com. Now, the thing that I'd also like to mention is there is overlap across these industries. So I'm talking about them as three separate things, but there have been examples of 23andMe and other large DNA testing companies buying up companies from other industries or collaborating with pharmaceutical and the insurance industry. But also Match.com has been buying up other dating platforms, and it does mention Facebook quite a lot in their contract. Match owns Tinder, and Tinder's contract and privacy policy are very similar to the Match.com one. And you'll see even in this clause here that I've provided, it does actually mention information that's provided to them through Facebook. And it does have a non-exclusive license, which means it doesn't stop you from doing stuff with your content. But it does mention an exclusive license in relation to screenshots of their services. Now, when we think about this, I'd just like you to think about what it might actually be capturing. So you can note the similarity of the language used here. It's similar to the other two industries, wearable tech and direct-to-consumer DNA testing, but and it's also similar in terms of the scope of the term being very broad, and also capturing known and future technology. But the mention of the use of screenshots to a user's content is quite an interesting one in the context of online dating, because if you think of what a company might actually be taking a screenshot of here, this might be a user's profile, for instance. This might have photos on it. This might have other sensitive information that they might not want shared. So it's quite an interesting one to have this exclusive license to screenshots of a user's content. And there are similar terms in the Tinder contract. And this might, I'm not sure if this is surprising to some people, but it's something that I think more of us need to be aware of, and particularly when we're dealing with our young people, to have honest conversations about how to be safe online as well, and what data you might not want to share is something just to be aware of too. And thinking about sensitive data in all of these contexts. So certain forms of data may serve as a unique identifier. So genetic information is probably one of the most sensitive forms of information, and it will serve as a unique identifier for you that can't be changed. It means that that's a piece of information. Once you have your genetic information sequenced, that genetic code is not going to change over time in a way that would mean that we can't link it back to you. And because we share a lot of our DNA with our families, that also creates other possibilities for their privacy to be infringed. But in the context of wearable tech and online dating, there are other forms of data that they might be collecting, which might also act like unique identifiers or be a unique identifier. So for instance, Fitbit and Garmin and some of the other examples of wearable tech will track footsteps and other aspects of a person's health. This doesn't always qualify as health information. Sometimes it may qualify as biometric information, but some of that information could also identify you to people with the right skill set. Because, for instance, if we're thinking about someone's walk, it's actually very difficult to change your gait. And it has been possible in studies to identify people from the way they walk in a building and smart building infrastructure systems. There have been examples where the military have had military personnel wearing smartwatches or wristbands, and found that that actually has revealed the locations of it's been possible to identify military locations through the routes that these military personnel are taking wearing these devices. It's also been possible in genetic studies to identify people in quite large data sets without access to very much information about them. And it's likely that you're going to be able to do that with other forms of biometric information in the future. And as more things are being linked together, we need to also think about the very real reality of things being spoofed. Even if we think about developments in artificial intelligence in the last couple of years, particularly advances in deepfake technology, it's going to be very possible. The more information you put out there, the more likely it is that someone with the right skill set is going to be able to harness that to pretend to be you or to rip you off in other ways. So the unfortunate thing is that all of this information, and sometimes if we think about for instance, the recording of all the messages that you write on a dating platform, or messages that you put on some of these other platforms, that can amount to screeds of information. And so the risk of a data leak doesn't necessarily decrease over time if businesses are wanting to use that data in research and share it and store it. So thinking about unique identifiers, just to reiterate this point though, for things that really are unique to you and could be used to identify you, it's not easy to change them. So if something goes wrong with your bank account at the moment, you can normally change your PIN number and that will solve things. Certain other types of numbers, it's very difficult to change. So in the US, for instance, if your social security number is compromised, it's very difficult to get a new one. And that's meant that people who were victims in the Equifax data breach might have people taking out credit cards in their names for the rest of their lives. So there's a lot of consequences for people where something does go wrong here. And there's a few takeaways I'd like you to take out of what I'm talking about today. So free industries that handle sensitive data, but if you're a person who's interested in doing any of these things, I'm not knocking it. I know plenty of people who have met their partners through online dating platforms, or who use wearable tech, or who want to find their ancestors through genetic testing. But please do some research first. Think about your level of comfort with different types of your information being shared, and who are you actually comfortable with that information being shared with. Also, think about the very real reality of what happens if something goes wrong. So in the 23andMe example, there's lots of information that was released, and some of that might not seem that innocuous, but if you're in a particular situation where you don't want lots of people to know your home address who might have bad intentions, or you don't want certain other information released that could impact your insurance coverage or your job prospects, it's really useful just to think about what you might want to do, because at the moment, this industry is in a state of flux. It's not really in a very good state because 23andMe was actually a unicorn company. There wasn't really an expectation that it would go quite so badly in this direction. But there definitely are consequences when someone has enough information about you to pretend to be you and take out loans or credit cards in your name. You can suffer quite a lot of financial loss through information being lost. If you're a business though, and you're handling personal and sensitive data, or you want to offer a new product that relies on sensitive or personal data, please think about privacy and security by design. I believe businesses can do a lot better here, and I think there is a market for more privacy-friendly services. I am often asked if there are companies that I would recommend that, particularly in the genetic testing context, that actually are more privacy-friendly and are more secure. And at the moment, I can't really recommend to anyone in particular. And the other thing is to think about the content of your contracts and policies. Think about what you really need to do with data, what kind of data you really need. Data minimization should be something that people really do take to heart in a lot of businesses. And often you can do something really great by focusing on a specific thing that consumers might want to use. And really consider those privacy enhancing services, because that's something where all the industries I've talked about have had problems with. And if you think about online dating as an example, that seems like something where it would be useful really to have some much more privacy enhancing services to allow people a bit more control, because as well as the examples of people meeting a lovely match online, there's often been a lot of examples of things going wrong there. The other thing, as a legal academic, I am in favor of regulating industries to a large extent. I do think this helps businesses to have certainty about what they can and can't do, and also consumers to understand what what is a responsible looking business, and how to identify a company that they might want to get a product from. I think there needs to be collaboration between regulators internationally. There has been a probe into the 23andMe breach conducted jointly by the UK's Office of the Information, Information, the UK's ICO, which is the Information Commissioner in the UK, and also the OPC. I was getting confused between the abbreviations, which is the Canadian Privacy Commissioner. They've done a joint probe, and they are monitoring the bankruptcy proceedings of 23andMe and what's happening there as well at the moment. So we may see a bit more movement there. There's, I think, a need for improved transparency and companies really trying to make it easier for consumers to understand what's going on and how their data will be used. I think we can have some useful amendments to existing legislation and also industry-specific legislation sometimes. I think having compliance reviews and audits is a useful thing. I think privacy regulators working together with consumer regulators is also a very useful thing that we can hopefully achieve some better results with. In the UK, there have been examples with their Competition and Markets Authority improving terms and conditions across some industries. So one really good example, which is a bit of an older example now, was working on improving gym membership contracts and allowing people to be able to cancel those or modify those at much shorter notice. And also, I think we need much, it would be good to actually have model contracts and privacy policies for specific industries to help businesses know what they really need to put in those documents. There needs to be more consultation, I think, across industries, but also just thinking about having things like mandatory codes of conduct and things that actually stick to industries, and much more oversight of what businesses are actually doing, especially if something's going to happen with a merger. If you're interested in the DNA testing context, this is a video I developed with an animator with Professor Samuel Betcher, and we're very, very grateful to the Bowen Foundation for funding this, but it is an animated video available on YouTube, which just talks you through things that you might want to consider before purchasing a DNA test online. And a lot of these things actually apply to these other industries. Just having honest conversations with friends and family about how you want your data to be shared and what data you want to put out there, are things that I think really can help. And if you're interested in my work, there's details of other things I've written that you may find helpful. And these slides will be made available fairly soon, I think, after this event. And thank you very much for listening. I'm very happy to take any questions now. I'll try my best to answer them, but my contact details are below. So. Okay. Okay, so the first question was around whether any of the providers, say for wearables, Apple Watch, are better than others in terms of privacy and security. I think Apple has been more focused on security in terms of the Apple Watch and also iPhone, but I'm not sure that it's well, there's still going to be vulnerabilities there, and there's still likely to be partnerships in terms of the data that you're putting into it. So, for instance, there's also another piece that I've written recently was about the proposed new European health data space, which there's a regulation, which is a new law like the GDPR, but which sets out to create two networks across the EU to share information. And that includes a new right to insert information, which will allow individuals to basically upload data from wearables and anything else they like to their electronic medical record, but there aren't really a lot of systems in place to support that at the moment, and that could create some security vulnerabilities, even where a company like Apple is trying to make quite a secure device, because if you share it with a platform that's across the EU, there is likely to be some vulnerabilities at some point across that network. And also just the capacity for GPs and other healthcare workers to grapple with all of this new information without a lot of new infrastructure, I think is going to be problematic. So I think Apple are doing better, and I'm not a big fan of smartphones. And unfortunately, when I first moved back to New Zealand, I found that I had to get one for banking. And I do have an iPhone because I trust it more, but I don't trust it entirely. So that would be my answer to that. How does New Zealand's desire to conduct random roadside drug testing, which majority of submission oppose, impact the collection and storage of our DNA? I'm not sure I can answer that question easily in this time frame. I'm not entirely sure whether they well, I think with drug tests, they might be storing samples, but I'm not entirely sure of that. So I won't delve into that right here, but I'll try and look into that a bit more. How can people protect themselves against breaches by family members? It sounds unlikely, and it also sounds like relatives would find it difficult to prove harm or claim redress. I think it is difficult, and that's why I tend to say, if particularly in the context of DNA testing, if you can have a friendly conversation with family, if one of you is thinking of doing this, it can be useful. Also, because some people are finding out that they're adopted or donor conceived through these services. And while generally that's probably going to be accurate, it's something that I would still generally recommend that people had follow-up testing in a clinic to confirm that, particularly if they didn't actually have any suspicion that they were donor conceived or adopted, because there have been examples of samples being mixed up. But generally, it's probably going to be accurate, but because that also might be very unsettling for someone, some people might have some positive experiences through learning that, but it's something that if you're on good terms with your family, you probably do need to talk about. And it is really difficult, because if one person's data is released, whether it's genetic information or health information that might include family history, then that is likely to impact other family members' privacy. So generally, my sort of advice is to have a conversation, but also just to think about your level of comfort and at least what you can do to protect your own privacy. Maybe because at the moment, particularly for health testing, I generally would recommend DNA testing with one of these companies. If you have a serious medical concern that there's a genetic test for, it would be better to talk to your doctor about that and do it in a clinical setting where there's those support networks as well, and a lot more governance already in place. Let's see. Next question. Health information exposed with use of vaccination passports here in New Zealand, saying it was not compulsory, but it sure felt like it was. Yeah, so I tend to agree with that. It's and I know there have been problems with people losing their jobs for not being vaccinated, and I think it's not been a good situation. So I do think if we're going to have mandates or things, and you have to reveal certain types of health information, then there needs to be a lot more protection over it. I mean, as an academic who's lived in several countries too, I shudder at the amount of information I've had to give up in different contexts, and it's something that I think we need a lot more public debate around and oversight. And I think the work of the Privacy Commission can help with that to some extent, especially with codes of practice, but it is difficult. I'm going to see what there's a couple of questions that I'm not sure about answering just here. I'm happy to be contacted. I don't think that DNA is collected for home births and expats, but I am not sure about that. In terms of wearables, so Meta Ray-Ban sunglasses will be I'm assuming that is it FR enabled and allow wearers to reduce the brightness of the light, indicating recording and use. What are our options to deal with these? Okay, so I think the metaverse and virtual reality and augmented reality, it is sort of coming, and some of that's coming through fashion tech like sunglasses. I don't think it's been quite as popular. Well, in the past, the examples that have come out have tended not to be quite as popular as I think some of these big tech companies thought they would be. I think we may need laws that limit, well, if we can't limit someone recording in a public space, then we may need to limit what types of things can be worn, but that's very difficult. I have concerns about facial recognition technology as well. I need to think a little bit more about my answer. I'm actually very uncomfortable with some of it, and I'm someone who I'm pro privacy and the protection of privacy. So some of these issues, I think it's going to be very difficult for us to grapple with. I think if you allow people more, I think there needs to be a lot more education too around the risks here and what are the benefits of certain technologies. I'm also someone who favors a precautionary principle approach, which is thinking that if there's too many risks of a particular technology, then it might be better to hold off on releasing it widely. Unfortunately, we do have a lot of products that come to market now without much pre-market review. So if we think about all the Internet of Things product range, or the kettles and fridges and things that come with connectivity built in, security is often an afterthought for those products. And I do think we need a lot more thought about that at the moment. And also thinking about the environmental impacts of some of these technologies as well. Because we really are relying on a lot of quite toxic things at the moment, and the waste culture that we have is also not helping. But I will try and think a bit more about that, and I'm happy to be contacted if you want to talk more about that. Okay. Out of interest, are you personally signed up to any of the services you covered in the talk? No, is the answer. As someone who's been married for more than a decade and someone who's been researching in this area, unfortunately, I haven't felt comfortable to have a DNA test with any of these platforms or to buy a wearable at the moment. As I'd be open to having a DNA test for a health condition in a clinical setting, but from what I've seen of the businesses in this space, I'm very skeptical about just having a test for ancestry, even though I'm interested in genealogy. In terms of wearables, I'd be more interested in things that were more privacy friendly in the future. But I sort of like to keep my data to myself. I'm a bit old school like that. And unfortunately, teaching in this area sort of puts you off doing a lot of these things. What difference do you think it would make if these companies paid for the data they collected from our use of their services? I think it would make a difference. One thing I forgot to mention is that in the context, I'll just take it one slide back so people can see things to read. But in the context of most free services online, like Facebook and other social media platforms, there's been a line for a long time that you're the product and not the consumer, and it's not really free, you're paying for your data. Unfortunately, in a lot of these contexts now, I would argue you're both the consumer and the product still. And that's because you'll see that, for instance, 23andMe and most of the direct consumer testing industry, they charge for their services. They do sell tests. And actually, a lot of online dating platforms also charge now, although they might have a free option, but they do tend to, some of them do rely more on subscription-based services, and wearable tech generally charges. So unfortunately, you're in the situation where you're paying for a product or a service, and you also may be the product because they're harnessing their data. If they paid you a really large amount for your data, my attitude would be a bit different. I do think there are possibilities for making platforms where you do actually pay users or compensate users if you develop a viable product afterwards. So, for instance, if we think about direct consumer testing, where they are researching a particular health condition or working with a particular group that's related, they could give back. They could give you some form of royalty. They could benefit local communities by doing that. And the potential is there because most of them will already have your financial information. So it's not that hard for them to compensate people. But it's not something that they have been heading toward. Well, they have not been heading in that direction so far. And are there any other questions? There was something in the chat. I thought the chat wasn't. Oh, someone's put the link on the screen. Oh, thank you. Yeah. So that article about 23andMe and the bankruptcy proceedings, there are now deadlines by which you have to file a cybersecurity incident claim, which is also problematic because it may mean that some people legitimately lose out. But I have genuine concerns about whether people will be compensated at the moment because it's been put on hold. Are there any other questions before I go? Just see. No, just missed. Oh, okay. Oh, that's a good question. So Fitbit's privacy policy seemed to really change after it was bought by Google. So the other thing just to bear in mind here, I mentioned about the industry the industry is collaborating with other industries and buying up other companies. There has been investment by big tech in a lot of these spaces. 23andMe was founded by Anne Wojcicki, who used to be married to Sergey Brin, who was the co-founder of Google. Google did invest heavily initially in 23andMe. There's been other examples of collaboration between Ancestry and another entity owned by Google called Calico. And there's been linkages between 23andMe and Fitbit and other entities. So there's a lot of sharing going on, I would say. And it doesn't surprise me that the privacy policy changed after Google bought it. We could think back to the example of Instagram. They had improved their terms and conditions at one point, and then they were bought by Facebook, Meta. And I think their terms are probably not as good as they were prior to that. And the other thing just to really recognize is just the sheer scale of some of these entities. So these companies rival national governments in terms of resources. It's very difficult for an individual person to challenge that. It's even difficult for our regulators to challenge that as a small country. Yes, and last question about one of the issues of 23andMe, getting data out of the system, what happens to your request if they've gone under. I think that is the problem. And my general thought for some time has been that once you put your data in one of these systems, it is difficult to get it out. Whether the company's doing well or badly, it's quite difficult to control where it ends up. And even if you are told it's been deleted, it may not have been. I remember prior to COVID, meeting some people who've been working around enforcing Californian privacy law, and I was told that some entities like Facebook, when they say you've deleted your account, they may just be deactivating it because they think they're going to get sued and they want to retain the information. I suspect sometimes, particularly with the really big tech space, I think that may be happening. I think with smaller companies who really want to have good reputation and have more value in their reputation, actually, it's more likely that they're really going to do their best to do that. But if we think about other examples where information is shared without our consent or knowledge and then uploaded widely, it's very hard to get all that deleted if we think about things like non-consensual pornography and other things like that. Yeah, so I'm hoping that sort of tackled most questions. But thank you very much for listening to me, and I'm very happy to talk again and to have any more questions. So thank you very much.